John Romano out of West Palm Beach, Florida. I was sworn in on May 10th of 1974, the most excited lawyer in America. When I woke up this morning, 48 years later, I'm beyond excited, beyond enthusiastic. Emotion and passion and feeling and the blood of life is what these cases are all about. And when the clients come in and you start to feel the emotion and you're already thinking, I can see where the depositions are going, I can see where the opening statement is going, I can see where the summation is going. That's what wonderful lawyering is all about. First goal in voir dire is identify those jurors who frankly are not going to in any way want to identify with you or your client. Number two, establish credibility and rapport with the jury. And number three, put the case out there in an understandable way to where the jurors begin to understand some of the issues in the case. The only way you can determine whether or not a juror should be challenged for cause or removed for cause is by discussing those issues. Number one, be a teacher. So during opening, I want our lawyers to go to an easel. And if you explain the issues in the case, you are writing them on there. Issue number one, issue number two, etc. Second point, speak as an advocate, not as a neutral umpire. You don't say, issue number one, was the defendant physician in breach of the standard of care in the care and treatment of Mary Jones? No. You say issue number one, defendant, doctor, ran medical red light. And then you put down your marker and you discuss that issue. Third, you tell the story of the case. Fourth, take the wind out of the defendant's sails. Those problem issues, you need to minimize those or eliminate those by discussing them yourself before defense counsel can get up and say, aha, they didn't tell you about this and they didn't tell you about that. The final piece of advice, relax. It doesn't have to be perfect. Just talk from your heart and you'll be fine. Statement one on direct examination. The focus needs to be on the witness. Think of the witness as the fighter pilot and I'm the wingman. Difference. On cross-examination is the first stage of final argument. I am arguing points looking right at the jury. There are some times when I conduct a cross and barely look at the witness because I'm making point after point that I intend to make in summation. Those to me are the two biggest differences, and they're powerful differences. To me, there's a structure to every summation. I would start with words to let the jury know they have an awesome power and a responsibility. I will remind the jury where they get their common sense from through their years of experience, and then I will go right into what are the issues. I will remind them of strong evidence on our side, and then I will take only a few of the defense points and do as best as I can to make those points vanish because they are invalid. You don't want to bring back a verdict to confirm what they were saying because it's false. Ultimately, when you stand in front of a jury for summation, that is that moment where you feel this is where I am today. This is what I was meant to do. It is a tremendous burden on your shoulders, but it's a gift to have a great burden. If there's 2 seconds on the clock, don't you want to be the one to have the ball? That's got to be your mindset. I want to be the one taking it. I want to be the one with the burden. I want to be the one with my arms wrapped around my clients so that we are going through everything together.